Well, we interrupt that live event. Of course, we'll be coming back there a bit later. I want to take you now to the Milimani Law Courts, where the Wajir Governor's election petition ruling should be going on as we speak. Just to give you some background, the former Wajir Governor Ahmed Abdullahi had challenged the election victory of Mohamed Abdi of Jubilee. Let's listen into those proceedings now at the courts.
Respondent's chief agent at Wajir East Tallying Center admitted in cross-examination that the results for the gubernatorial elections were declared by the second respondent. The explanation given by R2W1 was that after he had received results from all the other 5 constituencies, he noted that the results from Wajir East had delayed to come in. He therefore went to Wajir East Tallying Center to assist the returning officer in collecting the results. He denied taking over the duties of the returning officer at the tallying center and contended that he was doing his supervisory role. Mr. Manza submitted that the second respondent's action was contrary to Regulation 3.3 of the regulations and in breach of Regulation 4 and 5 of the regulations. That the returning officer wrongly delegated his duties to the second respondent. Counsel relied in the case of Geoffrey Kiragu Njogu versus PSC on the proposition that the returning officer could not delegate his duties to the second respondent. On Ms. Okimaru's part, she submitted that the allegations of offences on the part of the third respondent's officials has to be proved beyond any reasonable doubt. That the visit by the second respondent to Wajir East Constituency Tallying Center was meant to offer administrative assistance to the returning officer. She saw nothing wrong with that. The appointment and duties of the constituency and county returning officers is set out in Regulations 3 and 4 of the regulations. In those regulations, the county returning officer has no role whatsoever in a county tallying center. The regulations do not provide that the county returning officer has any supervisory duties over the work of a constituency returning officer during the tallying of votes at the constituency tallying center. While the regulations define the returning officer to include the county returning officer, Regulation 5.3 allows a returning officer to preside at a polling station. If it was the intention of Parliament that the county returning officer supervises and undertakes duties in the constituency tallying center, nothing would have been easier than to expressly state so, as it did in Regulation 5.3 of the regulations. Further, neither the second respondent nor the third respondent produced any evidence to show that in his letter of appointment, the second respondent's duties included a supervisory role at the constituency tallying center. It was not shown that the third respondent had extended this mandate to the second respondent under Regulation 4.1d of the regulations. The second respondent testified that he visited the Wajir East Constituency Tallying Center to find out why there was delay in the submission of the results from that constituency. That he found that the returning officer R2W2 unable to proceed with the tallying because of the over-vigilant agents who were objecting to every step taken by the returning officer. He took over the process and finalized the same. He then proceeded to declare the results for that constituency as testified by R1W4. On the foregoing, this court makes a finding that the second respondent acted with travails by taking over the process of tallying of the results at the Wajir East Tallying Center and declaring them. However, the court notes that Form 37B, which contains the results for that constituency, was signed by the returning officer gazetted for the area, R2W2. Nevertheless, the conduct of both R2W1 and R2W2 was contrary to Regulations 3 and 4 of the general regulations. This, however, did not affect the results of the election. The petitioners allege that the second and third respondent failed to secure ballot boxes and ballot papers. But a driver of one Mohammed Elmi was found in possession of a ballot box and ballot papers. He was arrested for that offense. A police report made at Wajir Police Station was produced as AMM26 at page 164 of the petition. That fact was not disputed. The court notes, however, that the subject material was related to the position of member of National Assembly. The petitioners did not demonstrate how the loss and recovery of the subject ballot box and Form 34B affected the gubernatorial election, and the allegation is therefore rejected. The petitioners allege that there was wrongful opening of ballot boxes from Basineja Center and Batalu Primary School polling stations. PW6 Ahmed Abdikadir Nuno testified that on the 9th of August 2017, he recorded the returning officer for Wajir North forcefully opening 12 ballot boxes for the 2 named polling stations. He produced photographs and a video clip AAN2A and B, which captured the entire exercise which took place at the Wajir North Tallying Center. Protests from him and other people fell on deaf ears. The video clip was played in court during the hearing, which confirmed the testimony. R2W5 Nur Gedi, the returning officer for Wajir North constituency, admitted this allegation. He explained that this was occasioned by the fact that the ballot boxes were delivered to the tallying center with the results sealed inside. That since he needed to declare the results, he informed those present of the fact and then proceeded to open the ballot boxes as stipulated under the training manual and guide for returning officers. That he removed the results, declared them, and had the ballot boxes resealed. That these facts were captured in the polling station diaries for the respective polling stations. He contended that his action of opening the ballot boxes did not prejudice anyone. Mr. Mwanza submitted that the opening of the ballot boxes was in total disregard of Regulation 93(1) of the regulations, that the fact that there was no copy of the results posted at the public place within the affected polling stations or the side of the ballot boxes or in the possession of any of the agents was also a violation of Regulation 79 to A, C, D of the regulations. That the said action of breaking the ballot boxes interfered with the integrity of the election. Ms. Okimaru, on her part, submitted that the breaking of the ballot boxes had been explained by R2W1 and R2W5, that there was nothing sinister with the said act as it was only meant to procure the results for the two polling stations. That the was an irregularity that did not affect the results of the election. She cited the Court of Appeal decision in Richard Nchabin Laiyagu versus IBC in support of that proposition. A reading of Regulations 81, 83, 86, and 93 of the regulations will show that once the ballot boxes are sealed at the polling station, there is no authority whatsoever to break open those ballot boxes without an order of the court. The attempt by the second respondent and R2W5 to rely on what they called the training manual and guide for returning officers cannot do. The third respondent cannot arrogate to itself power which it does not have under the law. It cannot amend the law through internal manuals. If that is its intention, it should lay those amendments before the people's representatives in Parliament for enactment. By attempting to allow the returning officer to break open ballot boxes at the tallying center after they had been properly sealed at the polling station, the third respondent and its returning officer acted ultra vires. I hold that once a ballot box has been sealed at the polling station, no amount of consensus by electoral officers and agents and candidates can validly lead to its opening without a court order. The act of voting is an exercise of the sovereign will by the citizen, which once exercised and the process finalized at the polling station, no one is allowed to tamper with the material that contains that sovereign act unless by authority of a court of law. It does not matter that the returning officer only wanted to retrieve the results from the ballot boxes. That the third respondent would employ presiding officers who are ignorant of what is required of them is an act of sheer inefficiency and incompetence.
Well, we apologize for that technical hitch, but what is happening at the moment is that a reading or a ruling is being read out on the Wajir gubernatorial election petition, and that's what we were bringing to you live. We want to take you back there as soon as we can get that signal up, but in a nutshell,